Hello all. Welcome to our next webinar in this series arising from the lockdown claim. My name is Aaron Bolton. I'm a managing associate with Morrissey Law Advisory, and with me, joining me shortly now is Jonathan Frost, from director at Bellrock Broking. This is a webinar dealing with insurance arising from lockdown. The question we've got there is, do I have a claim from lockdown? Jonathan, I'll just chuck over to you to introduce yourself very quickly at the start of this.
Yeah, thanks, Aaron. Yeah, so I'm Jonathan Frost. I'm an insurance broker and risk manager to the construction and associated industries in Sydney.
Excellent, thank you for that. So we're going to just kind of talk about a few things with what's arising from this lockdown now. The points we've got here, the talking points, which we're going to discuss quite broadly, are listed here. So what types of policies might people have that they can start looking at? Whether or not these could cover any losses arising from the lockdown or any of the events. If the determination is there might be some cover there, how do claims get made, and then the other kind of things that people should be looking at as well. And if we have some time at the bottom and a bit of a Q&A. So we'll probably just get started into it because everyone's pretty flat out at the moment with everything that's going on. So starting here, Jonathan, I'd like to get you just to chat generally about what types of policies people might have who've been affected by this lockdown and generally what they're meant to be dealing with.
Absolutely. So broadly speaking, you've got what we call material damage policies, which take the form in construction of contract works and in operational property under an industrial special risks or ISR. Attached to those policies is generally a business interruption section, which is there to try and put a business in the same position it would be financially following a loss as they were prior. Public liability really and professional indemnity are third-party liability policies. So generally speaking, when we're talking about lockdowns and financial losses that you have incurred as a first party, those policies wouldn't be in play for the purposes of today's discussion.
And so when you're talking there about first party and third party losses, what are the kind of things people are thinking of there if they're not sure what they might be able to get cover for or along those lines?
Well, the easiest way to say it is first party is if the loss has affected you directly and your possessions, and a third party loss is loss that you've caused, either legally liable for or contractually liable for losses you've caused to another person.
Okay, yeah. So the latter claim there, the third party ones, generally you're gonna have to get a bit more of a trigger, third party coming at you for something as opposed to just something you happen to spend. Yeah.
Yeah,
okay.
That's right. You've either hurt them or you've injured or you've damaged their property.
Okay, cool. So for anything around the COVID, what we're more looking at here is first party cover, first party kind of losses. Okay, now I think that's the best place for people to start when you're looking at these things. So moving on here, we've got a list of policies with a list of abbreviations, acronyms that some people might be familiar with. We think these are the policies that people might want to start looking at. Jonathan, can you have just to have a run through there about what the things to consider under these particular policies, what the acronyms mean probably as well to start off with, and then where people to go?
Yeah, absolutely. I mean, there's no doubt that the insurance industry loves a three-letter acronym or more. So if you look at, we've got their business interruption or advanced loss of profit. So they're the policies that exist alongside your ISR, which is a property policy, and your contract works or CAR. The BI, business interruption or advanced loss of profit, is intended to cover financial loss as a result of damage caused during construction or to your property in general. Advanced loss of profits is something that has existed for a long time in the insurance market, is very seldom purchased on an annual basis. I would say that it's purchased really to support financiers on large mega projects. So it's very rare for us to see any project take out an advanced loss of profit unless it's driven by a financier's need or a principal's need. And the reason for that is generally it's quite expensive. I would say from the outset, for the purpose of discussion today, because there will be a lot of discussions around legal cases on business interruption and COVID, it's generally accepted that insurers have intended to exclude financial loss arising out of pandemics for some time, specifically since the SARS outbreak in 2002, which at that time there was very little in the way of exclusions, and a lot of insurers were caught out under the business interruption sections of their policy. And when they analysed the potential cost of losses arising from such pandemics, they realised they didn't want to be, or they couldn't afford to underwrite such losses.
Okay. Now, moving on to the ISR, what are the kind of things that people are looking at here?
Yeah, so an ISR policy will cover your property. So if you're a factory, it'll cover all your machinery and your buildings, and then the business interruption generally will be your revenue that you're losing as a result of damage to your property. The only trigger for all property policies generally is damage, or a specific trigger whereby the insurers define a certain event as being damage. So closure by public authority obviously doesn't generally cause damage to your property, but an insurance policy will be triggered because they'll declare that to be damage. Contract works policies always and have always had specific exclusions around consequential loss, financial loss, liquidated damages. Those are viewed as commercial risks, and putting aside for a second COVID, if you look at the types of things that are going to cause you delay and costs, generally there'll be liquidated damages regimes in place to protect your principal, and you'll have those reflected downstream contracts as well. And insurers really don't want to get into the middle of a commercial contractual arrangement between a builder and a principal, because really if the insurers were picking up the bill for that, there'd be nothing to stop liquidated damage regimes from being significant because the insurer's paying the bill for them.
Yeah, no, and quite a common thing to exclude those kind of losses generally across policies. Is that probably in construction as well? Is that probably right?
Yeah, most insurers won't want to pick up under any type of policy liquidated damages.
Yep. Okay, so here, even though the policy, for instance, the ISR, perhaps sometimes or might have some type of trigger there. So I guess for anybody who's starting to look at their policies and see where the cover might be, it's maybe sometimes not in the most obvious place, the most obvious policy to be found. But so it's important to undertake the review of the policies that you do have, and check these things properly, and speak to your broker and check them properly. Yeah,
absolutely. I mean, they're not always obvious in terms of the coverages under policies. Everyone kind of understands what is meant to be covered, but the devil is in the detail. So it's always worth understanding exactly what your financial loss is, and then taking that to somebody who can provide you advice around your coverage.
Excellent. Okay, so there's the kind of policy we're looking at now. I guess we've got speaking today, we've had the fortune of having had a test case run in New South Wales around a COVID exclusion and COVID cover for business interruption losses. So this case was decided recently, HDI Global Specialty and Wonkana. Now, in this case, the exclusion concerned around quarantinable diseases under the Quarantine Act 1908. And insurers sought to rely upon that exclusion, which also included words and any subsequent amendments. Now, the New South Wales Court of Appeal found for policyholders here, because this COVID-19 was not a quarantinable disease under the Quarantine Act, for the simple reason that that act had been repealed and replaced with the Biosecurity Act 2015, which commenced in June 2016. So on that basis, it was largely on that basis, the court determined that an exclusion was not able to be relied upon by insurers, and that the loss would, if otherwise covered, be covered, but the exclusion wouldn't be activated. That question was taken for a special leave application to the High Court, which refused special leave to appeal, which under Australian law is really the end of the line there. Nothing goes to the Privy Council anymore. So I guess the interesting thing here was, Quarantine Act 1908, Biosecurity Act 2015. Was this probably just a bit of an oversight because no one was really thinking about it, or is that probably, we mentioned before that it wasn't really intended to be covered? Is that what we think might have gone on?
Absolutely. I think when these wordings were drafted in the mid 2000s, it was valid that it was the Quarantine Act, but I also think that it's important, irrespective of the intention of the insurers, for them to have their policy. It's their policy. They've issued those policies. They've put those wordings together. No broker has sought to change or amend those wordings. And I think if we went down the rabbit hole of insurers being able to decide what they meant by something rather than having it interpreted from the insurance contract, I think we'd be quite concerned, because if you look at the wider ramifications for them to decide what they intended to put in a policy or what they intended for an exclusion to mean, that's pretty dangerous.
Absolutely. Okay, so that was the first test case that we had, and that's already been decided, and the road's been run on that. There's also a second test case being run in the federal court, also out of New South Wales. This one involves 6 different insurers across 10 different proceedings, and it's been heard together to determine the meaning of certain policy wordings around COVID. Now, this we'll call it this second test case involves a lot of the big insurers, in the domestic market. I think Allianz is involved, Australian Insurance Group, QBE, Guild, and I think there's one or two more that I just missed then. Now, it's set down for a hearing in August, and the federal court has made it very, very clear that they're going to deal with this and any appeal so that everything can be wrapped up by December. So at the moment, we haven't got any definitive answer on whether or not how the courts are going to determine these other peculiarities and important peculiarities in different wordings and different policies concerning COVID and business interruption losses. There's on the Insurance Council of Australia website, they have said that it's their intention to continue to deal with claims that have been finalised on the basis of the finalised outcome. So to the extent that an insurer is relying upon the Quarantine Act exclusion, and that is their only thing, that I think the intention there is that claims will be processed. However, if not all claims are going to be based upon that, and not all the declinatures will be based on that. So to the extent that anything being run in this second test case is up in the air and not determined, it's unlikely that insurers are going to continue to deal with that. Is that how you guys are seeing things at the pointy end, Jonathan?
Yeah, absolutely. And I think that it would be fair to say that this latest COVID outbreak, if we want to call what's happening in New South Wales and Melbourne, there wouldn't be an insurer in the country, I wouldn't think, that hasn't fixed the problem that we're seeing here. So really, we're now talking about proceedings relating to events that happened more than 12 months ago. We're probably talking prior to May last year, is really where, if there is any success in this thing, the trigger is going to be policies that were issued prior to May last year.
And so how would, if someone's not sure, how would, if you have a policy in place that would have been put in the new terms sent out to you or endorsements, how are people going to be able to know if these things have been checked up? I assume it's not going to be given a big red flag, or what should we be looking at?
No, exactly. I think that ISR policies will just have that. They've always had this exclusion relating to the Quarantine Act of 1908, and they will all just have exactly the same exclusion but reference to the Biosecurity Act.
Yeah. So just reading the contracts, reading the detail, getting right across that, which is unfortunately what we as lawyers say, and I'm assuming you guys as brokers say quite a lot. Okay, so now we're talking there about a test case in Australia on those parts of the policies. We've also got the fortune here that there's actually been a case in the UK that's dealt with these. The case reference is the FCA versus Arch Insurance. Now, there's a table there that's not particularly interesting for a lot of people, but these are those issues which are being raised in the Arch Insurance case in the UK are somewhat similar to the issues that are being raised in the second test case in Australia. So the interesting, while it's not possible to draw any definitive conclusions about how the Australian courts are going to determine the issues that they are addressing by reference to the UK decision, we are also a common law jurisdiction. We follow precedent, and the UK generally, in insurance particularly, is found to be quite persuasive. I guess it's fair to say in the UK, the policy orders were considered to be largely successful in their claims dealing with these similar issues. Is from your point of view, is that how insurers are preparing for this second test case to be determined, or given the differences in circumstances, and are they really quite, if to the extent you have any understanding of what they think their outcome's going to be, do they think it's going to be largely different here?
I don't think that they necessarily think that the outcome will be different. I think that I don't think they can afford not to argue the case. I think they need to make the determination. I think that's the important part. So, but as you say, I'd be very surprised. The exclusions were different in the US. So in the UK, the Australian policy form with the industrial special risk form is a kind of uniquely Australian form. So it's not identical to the British property policies that are issued, nor American. So it could be the case that we see a different outcome just based on the formation of the contracts, but the differences between the contracts of insurance in the two jurisdictions.
Yeah, and I think this is, I was having to dig around at some other jurisdictions. I think that a lot of these cases are still getting off the ground. Are you aware of any other areas that have dealt with these as well?
I think there's similar test cases going on in a number of places, and that's probably driven by the fact that a lot of these insurers would be supported by the same reinsurance companies out of the UK and Munich and places like that, where there is some consistency right at that back end, if that makes sense.
Yep. Okay, so moving on from the test cases we got there now. People have had a look at their policies. They've looked at the losses they've suffered, first party versus third party. They've spoken with their brokers and their lawyers, and they'd like to think that there's a claim to be made. What are the actual practical steps that people could be doing, or even just to protect your position now, that people should be doing to the extent they're suffering any loss towards making a claim?
I mean, it's all about the accuracy of records and tracking the information that you need to properly quantify your potential for claim. You need to understand, I think that we all expected that business would go backward as a result of some of these lockdowns, and I would probably say that a lot of our clients haven't necessarily seen a financial loss, nor have they seen the type of loss that they may have expected, and a lot of them have made up ground following short lockdowns. So the demand in the economy has still been there, and we've been quite fortunate in Australia. So I think understanding that if you've had a financial loss, you need to offset against any gain that you've made, so that you can really understand what your net loss is, and being able to articulate that to an insurance market, or firstly to your insurance advisor, so they can see what potential you have to make a claim under the applicable policies.
Who should people be talking to about those things? Is that external parties, internal parties, or?
Look, I think so. I think it says in that presentation that it's not the broker's responsibility to decline a claim. Your broker may take a view on whether something is covered or not, but it's not their job. The insurer is the person who holds the policy, and they need to make that determination. So, if you think you've had a financial loss, it can't hurt to press the insurer to have it declined or otherwise dealt with. If you're not happy with that determination, I think that's when you start engaging the services of a lawyer to have a look at the policy form, what was disclosed, and whether there's any other avenues or any other errors that might need to be pursued.
And so when you're talking there about offsetting losses, is that the job keeper and the other grants that were the job seeker and all that kind of stuff that was put on, is that going to all be relevant in coming to those calculations?
Yes, absolutely. Yeah. So any rebate that you wouldn't have otherwise received would be deducted from any income loss that you're attributing to the event.
Okay. All right. So now, apart from claims, we've got a 2-week lockdown on construction sites at the moment. 2 weeks. Is there anything else that people should be aware of or cautious of under their insurance policies? Particularly during this 2-week period, but also moving forward. Yeah,
look, I would say the number one thing, that no insurance policy can make you breach the laws of the land. So, you have the right to effectively shut the site and move away. But what you do need to understand is that sites are considered a much higher risk, whether they're an operational warehouse or whether they're a construction site. While they're unoccupied, they're at a greater risk of loss. What that means is insurers will generally have provisions in their policy which restrict or exclude cover if sites are left unoccupied or work ceases at a construction site for a period of time. You need to speak to your insurance advisors and find out whether any such limitations apply, and then notify your insurer that that there is a lockdown, and if you are going to breach a 14-day unoccupied premises exclusion or cessation of work clause in your policy, that you're going to breach that and you need their assistance. I don't think any insurer in the land would be game enough to say bad luck if you went to them and said that that's going to happen. When I say a decent, that's probably a bit unfair, but most policies will give you 30 days. But I have seen some that will only provide 10 or 12 or 14 days kind of grace between when work stops and when they come off risk.
So that work stopping would be, I guess, from Monday, right, when those orders came in, I imagine,
yes.
Took effect. So, okay, so check your policies, check the cessation of work clause to make sure that that's dealt with. In terms of, we've got here taking reasonable endeavours to protect your property. Is this just on a case-by-case basis, or how's that kind of construed?
Yeah, look, I think, the insurers would want to see that you just haven't left the gates swung open and you've just walked off site and left everything out in the open. Since we prepared this slide pack, I've had clients who have suffered loss. There's a building material shortage in Sydney, and I believe all the way in New South Wales up the coast at the moment. Timber has been getting stolen from construction sites on a pretty regular basis, and I've already had clients in the Sydney metro area who have suffered loss in the last couple of days from timber being stolen from site. So there's no doubt in my mind that while sites are closed, there's going to be people looking for ways to make a quick buck out of stealing from someone else. So insurers will want to see that you have tried to lock up the site and you've done what you can, bearing in mind that they don't expect you to be camped out on your site and protecting it 24 hours a day.
Yep. Yeah, the element of reasonableness there gives both parties a bit of scope. Okay, so we've covered that relatively quickly. A few questions have kind of come through, but what I just thought I'd ask first of all is, you've had a few questions about some things being stolen from site and a few people coming. Is there any other kind of common questions that have been raised with you guys yet, or is it all still kind of trickling through? Or
it's really been around what actions they need to take to secure the sites, because you've obviously got third-party exposures as well, and the principals don't necessarily, or the people they're working for don't necessarily want to be on risk. But how can you be held legally liable if somebody trips over on your site when you're not able to be there? It's really, I suppose, they're the questions we're fielding, is the uncertainty, and a lot of that is, do all you can, do what a reasonable person would do in your circumstances, and if you're asked to justify why you did what you did, have an answer for an insurer or for anybody who questions that.
And just asking you to whip your crystal ball out now. So we move forward 2 weeks and this lockdown ends. If there's going to be a bit of a spike in the kind of claims, do you think that's going to be likely rising out of this, or do you think insurers have got their ducks in a row, so to speak, as coming from last time, and we probably won't see as much activity arising after this lockdown?
Look, I don't think that we'll see any real property claims come about. I suppose the real question will be whether or not you can link the current COVID event or the current lockdown event to the event that occurred in March last year, and try, if policies are triggered due to the incorrect wordings, whether or not you can try to link this loss to that original event that occurred in March last year. That will be the telling thing, because that will make a significant difference to to the quantum of claims paid by insurers. We're already in a market that's difficult, challenging and expensive, what we would refer to as a hard market. And I would say that if they start paying COVID claims, things are going to get a lot worse for insureds in terms of premium over the next 4 years.
Yeah, of course, and the hardy market, which has been quite spoken about of late. One of the questions that's come through to us is talked about the orders that have been made, the health orders particularly. Access is allowed for rectifying works that might deteriorate. Now, if there is a deterioration of works, I'm just thinking out loud, and obviously putting you on the spot a little bit here. If that's something that occurs, is that likely to be kind of claimable under a policy during this period?
Deterioration versus damage, I suppose, is that question. The answer is if it's gradual deterioration, it's generally excluded, and those things are like rust and rust and erosion and those types of things. But where it's damage, if you've had to leave the roof off a residential dwelling and there's damage as a result of rain, insurers would be very unlikely to decline a claim on that basis, I would think.
Yeah, that's quite interesting, isn't it? Because and it's on Monday when we had this seminar, we had a question exactly about roofs being finished and unfinished, and whether or not they could go back. And the way that the drafting is at the moment, it's very unclear in what is urgent, what is not urgent, and there's so many factors that come into it. And you'd I guess empathising with people there, it'd be very hard done by if you were not allowed to go on and finish your roof, and then you weren't going to be covered for any damage caused by not having a roof. It's be a very, very tough situation for any insured to be in, any person to be in.
It's a pretty difficult, and without opening another can of worms, if somebody's renovating a house and only having a second-story extension put on, and water gets in through that opening because it's locked down and you can't go there, whether or not the contractor can be held legally liable for the water damage to that existing premises in circumstances where they weren't able to do any more than what they were doing to secure the property. I think that would be an interesting discussion.
Yeah, yes, very much so. Well, look, I think what we'll probably wrap it up there. We've covered up most of the things I think we wanted to cover. If anybody has any questions or anything else coming through off this back of this, we've got a few more seminars coming up, but Jonathan's details are up there. Feel absolutely get in contact with Jonathan at Bellrock, and if anything else coming off the back of it, we're always available. So, Jonathan, I just wanted to say thank you very much for your time. I really appreciate you jumping on this at such short notice. I know you've got 40 million things flying across your desk at the moment, so yeah, really appreciate that.
It was nice to put a pair of a tie on above my shorts.
Yeah, exactly. You and I both. All right. Well, thank you everybody for joining in. We're going to put this up and we'll circulate it as well out to the mailing list. So yeah, thank you all again.
Thanks very much.